Hello, my name is Joel Engel, and I'm an attorney at the Woods Fuller Law Firm in Sioux Falls, South Dakota. I'm part of the firm's robust intellectual property practice group. Our IP group assists clients in all aspects of protecting intellectual property. This includes helping our clients obtain and protect patents, trademarks, trade secrets, and copyrights. Today, I'm going to provide a general overview of the area of the law that is commonly referred to as intellectual property. This area of the law looks at a business's intangible assets and how a business can assert certain rights to novel concepts such as inventions, branding, proprietary information, and creative works. To do so, I'm going to focus on the four major areas of IP law: patents, trademarks, trade secrets, and copyrights. In doing so, I will explain how each of these areas are distinct from the other. I'll help you recognize what sort of intellectual property your business may have and how to protect it. This introduction will also give you a preview of some of the more in-depth presentations that will be available regarding some of these subjects. After this introduction, you should be able to understand where you are in the IP outline and decide which subject you may need further guidance on. First, they all implicate areas of federal law. The Patent Act governs patent rights, the Lanham Act applies to trademark rights, the Defend Trade Secrets Act applies to trade secrets, and the Copyright Act to copyrights. Notably, patents and copyrights are purely creatures of federal law. Trademarks and trade secrets are hybrids. Both state and federal law may apply. In addition, 3 of the 4 of these areas allow a business to apply or register for certain rights and protections under federal law with the U.S. Patent and Trademark Office and the U.S. Copyright Office. Our first topic today is patents. Many people have some understanding of the interplay between inventions and patents, and it's a good place to start to understand how federal law protects this type of intellectual property. At the ground level, a patent gives the patent owner the right to sue to prevent others from making, using, selling, or importing an invention. And it's a deal. The inventor gets 20 years of limited monopoly rights to exclude others from making the invention. And in exchange, the inventor discloses the invention to the public. After those 20 years, the invention goes into the public domain and generally is free to use by anyone else. There's a few different types of patents available to inventors. The most common type is what's called a utility patent. Utility patents protect a process, an article, or a composition of matter. When you see a patent for a new technology or process, you are looking at a utility patent. There are countless examples of patented technologies and products, including GPS, CRISPR gene editing, and Bluetooth. Even things that seem commonplace now, such as Velcro, microwaves, and light bulbs, once enjoyed patent protection. Patents can also cover more straightforward mechanical inventions, such as various types of attachments and equipment in the agriculture and construction industry. Let's talk about what's eligible to be patented. There's 3 basic requirements for the invention. The first is utility. That means the invention must be useful for some purpose. It can't just be an idea that has no useful application. Second, the invention must be novel. That means it hasn't been known before. Third, the invention must be non-obvious. That means the invention isn't simply an obvious combination of previously known elements. So those are the requirements for patentability, but who gets to decide whether these requirements are met, and how do you get a patent? All patent applications are filed with the U.S. Patent and Trademark Office. A patent examiner at the USPTO examines the application and determines whether it is entitled to a patent. The examiner may issue office actions or ask the inventor to narrow the requested patent claims. This is a complex process, and we always advise clients and potential clients to seek the assistance of an experienced patent attorney. While each application is different, the process typically takes at least 2 years. The patent is then effective for 20 years from the date of the patent application. A major pitfall for inventors relates to timing. An inventor has 1 year to file a patent application after the first public use or offer of sale of a product that embodies the invention. If more than 1 year passes, the invention will not be eligible for a patent. We've talked about what a patent is and how to get one. So what does a patent allow an inventor to do? The primary upside is that once a patent issues, damages become available for patent infringement. There are several types of damages available, including lost profits or a reasonable royalty. In willful infringement cases, attorney's fees and exemplary damages may also be available. all patent infringement lawsuits are handled in federal district court. Woods Fuller has handled numerous patent infringement lawsuits, both as plaintiffs and defendants. So what are the action items or key takeaways for your business? First, have you or has your business invented something that may be entitled to patent protection? If so, how long has it been in the marketplace? Remember the 1-year rule and be diligent with your applications. Second, if you already have a patent, are there others out there who may be infringing your patent? Or is it possible your product infringes someone else's patent? If so, you should consult experienced patent counsel to analyze any potential infringement issues. The second area of IP I'll talk about today is trademarks. A trademark is anything, words, a symbol, a color, a sound, that uniquely identifies a company's goods or services. This often gets referred to as branding. A company's name, what it calls its products, its color scheme, its logo. All of these can be trademarks. Understanding why we have trademarks can help you understand the scope of trademark rights. Trademarks serve two functions. First and foremost, we want to avoid confusion by consumers in the marketplace. We don't want consumers to be confused over the source of the goods they are purchasing. So, within a given marketplace, we don't want to allow companies to use confusingly similar trademarks. Second, we want to allow companies to create goodwill. Trademarks are receptacles for goodwill created by their users. This is a concept of a brand. Your business's reputation is embodied by your trademark. It encompasses the goodwill and reputation of a business. So for that reason, we don't want to let one business improperly capitalize on the strong goodwill and reputation of another. The most common trademark is a business name. Sometimes we call this a housemark. So Chevrolet, Apple, Google, Starbucks, all of these are registered trademarks. Within those brands, a business might have more specific trademarks for specific products. So Chevy Corvette, Apple iPhone, Google Chrome, these companies develop specific trademarks under its flagship brand or housemark. There are also different types of trademarks beyond just a business name. We typically discuss 3 categories. The first, broadest, and best are just plain word marks. A registered word mark protects all permutations of that word, regardless of the font or style. We also have design marks, sometimes referred to as logos. These are unique designs that identify a specific company or product. And then there's a combination of the two called composite marks. These combine both the word and design elements. Often, companies use all 3, as shown here. Also, keep in mind that trademarks aren't just company names. They can be slogans. When you hear "just do it" or "think different," your brain knows the source of those goods. A jingle can be a trademark. Think about the NBC tune. Even colors, under certain circumstances, can be protectable as trademarks in a given space. Think about John Deere green and yellow or UPS brown. What you should realize about trademark rights is that you may already have some, even if you didn't realize it. You often hear people say, "I'm going to trademark that." But the unique thing about trademarks is they exist simply by virtue of use. In other words, a company using its name to advertise or market its goods or services already has some trademark rights. But there's a catch. These rights are limited to the zone of use. So, a Pinnacle Brewing in South Dakota doesn't have trademark rights to stop Pinnacle Brewing in Florida. So how do we get rights outside that zone of use? The answer is trademark registration. Trademark registration affords a variety of benefits, but the primary benefit is the grant of nationwide rights for a trademark within a class or classes of goods or services. A registration lets you sue in federal court and prevents other users from registering similar marks for similar goods or services. And a registration gives a presumption that your trademark is valid, meaning enforceable in court. Like with patents, the USPTO is the federal agency responsible for registering trademarks. An applicant submits an application identifying the mark and specifying the goods or services covered by the mark and the date of first use. The examiner reviews the application to ensure that no confusingly similar marks have previously been registered. If not, and the other requirements are met, a registration will issue. Like patents, we advise our clients to use experienced trademark counsel to file trademark applications. Like with patents, infringement of a trademark can give rise to a lawsuit. Damages for trademark infringement can include disgorgement of the infringer's profits or actual damages if the plaintiff can show how it lost customers due to the infringement. In exceptional or willful cases, attorney's fees may also be recoverable. Woods Fuller has handled several trademark infringement lawsuits for both plaintiffs and defendants. So let's talk about key takeaways for your business for trademarks. First, ask yourself whether your business is using words or phrases to identify its goods or services. If so, you probably have trademarks and should determine how to obtain protection for them, including potential registration. Second, if you're looking at starting a business or a new product line, ask yourself what clearance work you've done. Have you investigated whether you might infringe any third-party trademarks? If so, you may have to consider rebranding. The third topic I'd like to discuss today is trade secrets. Trade secrets are sometimes called by different names, sometimes proprietary information, sometimes confidential know-how. A trade secret is defined as information that derives economic value by not being generally known, and it's also the subject of efforts that are reasonable under the circumstances to maintain its secrecy. This information can be a formula, a pattern, a compilation, a program, a device, a technique, or a process. Trade secrets aren't always grouped in with the other big three, and sometimes can go overlooked when analyzing a company's intangible assets. The easiest trade secret example is the recipe for Coca-Cola. The original formula is kept in a vault, and only a small number of people know the formula at any moment. It clearly has economic value by virtue of being secret, and Coca-Cola takes serious measures to maintain its secrecy. There's lots of other examples. Google has secret search algorithms that are trade secrets. A brewery's recipes could be trade secrets. Under the right circumstances, customer lists, pricing formulas, manufacturing techniques, all of these can be trade secrets. Importantly, trade secrets do not have a time limit or an expiration date. Protection for trade secrets lasts as long as they are kept secret. Contrast that with a patent, which only affords 20 years of protection. In some circumstances, trade secret protection may be better than patent protection. Going back to the Coca-Cola example, Coke never patented its current recipe. By declining to patent it, they were able to keep it secret and continue to enjoy trade secret protection to this day. Both federal and state law afford similar protection to trade secrets, and they both prohibit misappropriation of a trade secret. Misappropriation is defined as acquiring, disclosing, or using a trade secret which was derived using improper means. Improper means does not include reverse engineering, independent derivation, or other lawful means of acquiring the trade secret. So back to our Coca-Cola example. If a person could reverse engineer the formula, that would not be misappropriation. Let's turn now to key takeaways for trade secrets. First, ask whether your business has any commercially sensitive information. Does your business have any secret techniques, methods, or processes? If so, how is your business keeping that information secret? Remember, to be a trade secret, information must be subject to reasonable efforts to maintain secrecy. More often than not, that means confidentiality provisions with key employees and non-disclosure agreements with third parties. The last area I'll discuss today is copyrights. Copyrights offer legal protection for author of original works that are fixed in any tangible medium of expression. The copyright owner has several exclusive rights, including the right to reproduce the work in copies, to prepare derivative works, to display the work, and most importantly, to distribute copies of the work for sale. Original works take numerous forms. In general, if something was created or compiled by an author, writer, or designer, it's subject to copyright protection. The most common examples include books, articles, pictures and video, original music, lyrics, designs, and software code. In short, if a person created something in any medium, there may be copyright protection. Copyrights are unique in that they arise automatically. If you write a book or take a picture, you have the copyright to that work. And while these rights are important, they are very difficult to enforce without registering the copyright with the Copyright Office. For example, if you want to sue someone for copyright infringement, you must have a registered copyright. Without the registration, there can be no legitimate threat of a lawsuit, which may hinder the credibility of a demand letter. A timely registration also enables you to recover statutory damages. It can be very difficult to establish actual damages in copyright cases, so the Copyright Act provides a range of $750 to $30,000 per work infringed, or up to $150,000 per work infringed for willful infringement. Also, a timely registration enables a plaintiff to recover attorney's fees. Without this, suing for copyright infringement may not be worth it in some circumstances. Timely registration means registering the work within 3 months of publication. One of the trickiest issues we see clients wrestle with, especially when faced with potential infringement, is the concept of fair use. Fair use is a defense to copyright infringement. The defense allows you to use copyrighted works in certain contexts, such as criticism, comment, news reporting, teaching, and research. But if you are using copyrighted materials for a commercial purpose, even if you aren't directly making money from it, it's unlikely that the fair use defense applies. So posting a song or copying someone else's article on your company's website typically is not fair use. This is usually where a client will say, "It's okay, I provided attribution for the source of the material." But attribution is not a copyright defense. Without permission or a license from the copyright holder, you can still be liable for copyright infringement. With that said, let's note a couple key takeaways. First, ask yourself whether your business is creating materials that may enjoy copyright protection. Remember, it doesn't have to be purely artistic works like books or pictures. Even articles or marketing materials you create may have copyright protection. If those works are critical to your business, you need to prioritize which materials need to be registered with the Copyright Office. Finally, if your business's focus is not on creating these types of materials, ensure that you are not using works from third parties that may create exposure for copyright infringement. We've covered a lot of ground today, and I hope you now have a better feel for the key distinctions between patents, trademarks, trade secrets, and copyrights. Remember that patents, trademarks, and copyrights all need to be obtained or registered for their full benefits. Remember that trade secrets must be kept secret to enjoy protection. And as you think through these issues, try to perform an informal audit of your company's IP. Think about if there is intellectual property that you may not have considered. And for the IP you do identify, consider the steps that you can take to further enhance and protect your IP portfolio. Thank you for joining me today. I hope you found this information valuable in helping you protect your intellectual property.